At the Supreme Court this week, the Supreme Court denied the motions for partial reconsideration filed by the Bangsamoro Autonomous Region in Muslim Mindanao Government, the Office of the Solicitor General, and others. These motions sought to reverse the court's decision on September 9, 2024, which excluded the province of Sulu from the BARM. The decision is final and immediately executory, and the court will no longer entertain further pleadings. The Supreme Court also resolved to amend Rule 13 of the 2019 amendments to the 1997 Rules of Civil Procedure to provide for the mandatory electronic filing and service for civil cases in the first and second level courts. The court issued Rule 13-A, or the interim rule on the electronic filing and service of pleadings, judgments, and other papers in civil cases. This interim rule shall take effect on December 1, 2024, following its publication in the Official Gazette or in two newspapers of national circulation. Beginning December 1, 2024, all filing and service of pleadings, judgments, and other papers in civil cases in the trial courts must be done electronically through mail except for initiatory pleadings. The Office of the 2024 Bar Chairperson issued a notice announcing that the results of the 2024 bar examinations will be released on December 13, 2024. The results will be displayed on LED walls inside the SC courtyard and uploaded to the Supreme Court's official website and social media pages. The Supreme Court reiterated that child abuse cases can still be tried even when child victims are unable to testify in court, in accordance with the doctrine of unavailable child under Section 28 of the Rule on Examination of a Child Witness. It allows the admission of hearsay testimony of a child describing child abuse when 1. The child is unavailable due to death, physical disability, lack of memory or mental illness, possible exposure to psychological injury, or lack of reasonable means, and 2. Their hearsay testimony is supported by other evidence. This aims to prevent miscarriages of justice by allowing child abuse cases to proceed even if the child victim is unavailable. The court recognized that vulnerable children may be pressured to avoid attending hearings to prevent them from testifying. Some child victims may also be too traumatized to give their testimony. From November 27 to 30, the Supreme Court held the National Summit on Sustainability and Environmental Law. Guided by the theme, Enabling Environmental and Climate Justice, Bridging Science and Laws for Responsive Rules and Sustainable Development, a panel of experts discussed a wide range of relevant topics including climate change, energy issues, and environmental law practice. On November 28, the Office of the 2025 Sharia Bar Chairperson, Associate Justice Antonio T. Ko Jr., issued Sharia Special Bar Bulletin Number 1 on the schedule, venues, coverage, and other matters relating to the 2025 Sharia Special Bar examinations. The office also released the 2025 Sharia Special Bar Examinations syllabi. Visit the 2025 Sharia Bar microsite on the Supreme Court website for more information. Finally, the court has established guidelines for when a confiscated firearm must be presented as evidence in court. The court acknowledged that in previous cases, it had stated that the actual firearm does not need to be presented as evidence. To prevent confusion that could lead to the imposition of incorrect penalties, or even worse, the conviction of an innocent person, the court established the following guidelines on when the confiscated firearm must be presented in court. 1. Where an accused is charged with a violation of the Comprehensive Firearms and Ammunition Regulation Act, the exact same firearm confiscated must be presented in court. 2. When the use of a firearm is a qualifying circumstance, or when it changes the nature of the crime, and the penalty imposable depends on the classification of the firearm, the exact same firearm confiscated must be presented in court. 3. When the use of a firearm is an aggravating circumstance, or when it increases the penalty to the maximum period imposable, or is inherent in, or absorbed by the nature of the crime charged, the exact same firearm confiscated is preferred, but the presentation of secondary evidence may also be considered. And 4. In all situations where a firearm is confiscated from an accused, the confiscated firearm must be marked, photographed, and duly authenticated, and its integrity preserved. And that's your Supreme Court this week. I am Tiffet Indidoblatran, Supreme Court Information Officer.